Swayam Prabha. Digital India. Educated India.
Good evening, friends. Uh, Today I will present to you lectures on international trade law. But before that, I would like to introduce myself. Myself, Gurvinder Singh, working as Assistant Professor, Faculty of Law, Banaras Hindu University, and I teach there the courses on international trade law. Now, prior to delivering the lecture on the content, I would suggest what the course outcome is or what we expect from this course. We expect that there will be, after this teaching this course or after someone has taken this course, the person will have in-depth knowledge of the nature and function of the economic concepts and their application mainly through the treaty obligations. Earlier, the concepts that were known or that are known, they are not binding based on the treaty obligations, but since the international trade law is nowadays regulated by international institutions, therefore the treaties play its own role, and the course is designed in such manner that one start knowing the obligations that are set by the treaties. The course will enable students and researchers to develop an understanding and critically assess the effects of international trade. Also, since it is based on the regulations and the institutional setup is of such nature that it conducts meetings on an annual basis, on a biannual basis. The records are kept, so it will help the researchers and the students to know what are the outcomes of this trade concepts and also how this institutions is functioning in regulating the trade. Thirdly, the course will help to learn international and national measures taken to address current international crises and challenges. We all know that international trade sets its own aim and objective nowadays through the free trade principles, and therefore, after analyzing how far the free trade concepts have helped to meet those objectives, that will be analyzed based on whether they are able to solve the international crisis or whether they have ever been able to answer the challenges faced by the nations, the market challenges faced by the nation, the economic challenges faced by the nation. For example, the Sri Lanka has faced deep crisis, even Nepal, Pakistan, and many other the African countries. So can we say the international trade law concepts and the way it is being regulated by the WTO, is it functioning in the right direction or not? Lastly, this will suggest better factors and determinants for cross-border trade. So after analyzing whether they are rightly regulated, whether they are rightly addressed, then we can also give the suggestions whether there can be some more factors added or there can be replacement of factors and determinants for knowing better the international trade and even the functioning of international institutions, or we should stick with the accepted rules, regulations, and the order in which the international institution is functioning. Now, I start with the general ideas and theories on international trade that has been in existence prior to the formation of the WTO or the GATT or any such other international institution that has been regulating the trade. So it starts with when we talk about the historical concepts of the civilization. Human beings, they have the nature to know things from the different lands, not only to know things from the different lands, but also to possess things, also to exchange things. So that has generated the habit of trading across the borders. I mean to say, if some country is well known for producing good apples, other countries known for producing good oranges, so the human beings, out of curiosity, has been in the habit of exchanging these goods, or let's say these food articles, right from the very ancient time onwards. And that probably has led to the idea of trade across the borders. Now, I quote here what the ancient Greeks were practicing. From the ancient Greek to the present day, government officials, intellectuals, and economists have pondered the determinants of trade between countries. So, since we quote the philosophers from the Greek who has laid down the ideas on trade law and also the basic law that we study and is taught throughout, so definitely they were having certain ideas on international trade as well. And they advocated that human beings cannot, or a state cannot live very happily if it forgoes international trade, or if closes its borders for the trade across the land. Therefore, they have advocated this idea to practice the trade across the state. But then they also were very calculative, or at least they pondered upon whether we should, without calculating advantages and disadvantages, freely go for the international trade or freely go for the trade across the nations, or should we give a thought to it, or should we first analyze whether the practice of trade across the border is in the best interest of our country or not. For example, if a country is producing, let's say, good weapons, and the other country is producing good clothes, so maybe the country which is better in producing good weapons may not be willing to share its weapon with other countries, because it may realize that this will give its, it will be sharing of the technology or weapon technology to the other country. But for the other country who is good in producing clothes may not be facing the similar challenges if it shares its clothing ideas, or if it's technology how to produce the cloth. And that means the earlier philosophers or earlier thinkers on the trade concept, they were very much skeptical that to what extent we should allow the trade across the nations to pursue or to be continued, because of the security reasons and because it could lead to weakening of their own nation. Therefore, it was very controlled method adopted when the trade across the nations was practiced. But there was definitely the trade moving across the nations that we cannot deny. Next is they relied upon the determinants. That means what factors should be chosen when we talk about the cross-border trade. Factors means whether we have efficient labors, whether we have efficient resources, and can we share those resources and labor to the other countries. For example, let's say if a country has an abundance of iron, then if it sells its iron goods to another country, that will not harm the country. But if a country is deficient in iron ore, but maybe it's good in manufacturing iron products, but still wishes to export the iron products to any third country, then that may lead to some kind of extra burden on that country, that it has to firstly import iron ore and manufacture it according to its skill of the labors and then export it to another country. So that has to be very much rationalized, that to what extent we can allow the import and export between the countries. This was the idea during the ancient time. Whether international trade brings gains or losses to the nation. So the debate always remained whether allowing the trade across the borders will be helpful for the progress of the nation, or whether it will lead to some kind of economic loss. That has to be debated, that has to be analyzed time and again. This was what the ancient thinkers, or those who were propounding the state theories, for example Aristotle and all, they always had tried to rationalize this with the international trade concepts. Since the time of ancient Greek philosophers, there has been dual view of the trade. So we can put the idea of duality that was existing at that time between loss and benefits that nation will achieve after that international trade practice. A recognition of benefits of international exchange. No doubt, we cannot ignore that there existed certain benefits, because basically it is the consumers who get benefited out of the international trade or the trade across the nation, because they get variety of goods. Secondly, they are able to procure the goods at a cheaper price, sometimes even more efficiently, and also in a better quality. So they are definitely benefited, and those who are trying to rationalize those ideas, they must be very much clear that what are the advantages of the cross border trade. A concern that certain domestic industries or would be harmed by the foreign competition. But then, as I said, there is a risk factor involved, that the domestic industries definitely they face challenges from the foreign competition. That also happened nowadays. But nowadays we do not follow very strictly the protectionist policy, or after the inception of the WTO, we do not accept those ideas of the protectionism. But earlier, in order to protect the domestic industries, they always try to restrict the foreign imports, because that definitely would affect negatively the domestic industries. For example, the shipbuilding industry that started in Europe during the medieval time, that was very protectionist among the Britishers, the Scandinavians. Likewise, different analysts arrived at different conclusions. Despite all these different opinions, different, let's say, suggestions and inputs, different analysts have arrived at different conclusions, but by and large they have focused that there definitely is some better understanding and also some better objective achieved if we promote the idea of cross border trade, or so called international trade nowadays. Now the term, it starts with the term lex mercatoria. Lex mercatoria is basically the law of merchants. Lex mercatoria was a popular trade concept during medieval times, and it covered common way for merchants to trade and solve their dispute. Basically, it was based on the lex mercatoria concept was based on the law of merchant, that is how the merchants think, because the merchants are basically focused on their gains and losses. They are not very much like we have nowadays, very much innovative ideas, neither they try to take risk with the innovative ideas. But earlier the merchants were mainly focused on that if we promote the trade of this good, then we will be benefited. If we deny the trade of this good, then we probably will be saving our domestic industry. So that was the kind of ideas that revolved around these practices, and the term that is used for all this in general is lex mercatoria. It was based on the customary practices of the countries, because basically it was not someone, a merchant, a group of merchant from Arab world, or a group of merchant from Europe, they have devised any concept, but basically they were relying upon what their customary practices allow. So that means they used to move from one place to another in groups. They had a trading relationship that used to continue for generation and generation with different families, and they used to take loans. So they had their banking system according to their customary practices. So all this was based on custom and tradition. One example of such development is the law of sea, that originated actually through the customary practices of the merchants who moved around from one place to another through ships, and that led to the development of what we see today, the law of sea or maritime law. So it has a deep roots. The law of merchant has deep root. In present day scenario, we still can see those practices, like in India we organize fairs, what in Hindi can be termed as melas, where the traders, or let's say those who are willing to sell their traditional goods, they come from one place to another in those fairs, and then they sell their goods, the local made goods or the handicrafts. Likewise, that was happening in earlier times by the merchants who were moving from one country to another country, or one land to another land. It has gradually proceeded through two distinct phases until today, from ancient maritime customs to Middle Ages merchant guilds. So, as stated to you, that Lex Mercatoria was very much progressive in developing the maritime law that we see till date, and then the merchant guilds, that is the banking system, the financial institutions, because it's not modern day practice that there are a group of investors, or there are people who loan money to the others to take risk or to establish their financial setup or to establish their industry. But this practice was existing long time back also, and as stated to you, based on the families and the traditions of the family. So that has led to the merchant practices during the middle time, known as Middle Ages merchant guild system. The evolution of Lex Mercatoria was an important step towards merchant law arbitration and e-merchant law. So what we see today as law on arbitration, merchant law, and e-merchant law, we can trace the roots existing in the ancient time. Now, as we can quote the example of, or we can illustrate the law on arbitration, you see, usually the businessmen or those who are involved in the business practices, they would not like to waste their time that their dispute will be resolved after several court hearings, or moving from one court to another, and that may take years and years. So they would prefer to resolve their trade dispute by negotiations, or by making bargain with the parties. So that is what we see in the form of arbitration today, where out there is a legality with out of court settlement based on the negotiations between the parties or conciliation between the parties. So that is something that was existing in those times, has now been legally framed in the terms of arbitration law. International trade economists have linked free trade for technological progress, but there is a drastic change in modern times as it was in the earlier times, or even until the early Middle Ages. Now, what is the basic difference? Firstly, the early merchant practices were mainly relying upon profit and loss. Secondly, they were trading mainly the natural resources, or the food, or the crops, or anything what we consider today as handicraft. So they were not very much focused on innovation. Therefore, their idea of loss and profit was very much confined to those goods of trade only. But presently, with the new concepts of the economist, and how to multiply the wealth, or how to use wealth as a potential to progress technologically, the ideas have fundamentally changed. And nowadays, trade is regulated mainly by the institutions, and the focus of the trade is how to improve technology, and the technology creates an added value to the wealth of the nations. It is not only the technology creates an added value to the wealth of nation, but whoever promotes the new ideas in technology, or whoever leads the ideas of technological progress, individually can also be benefited economically. That is how we do through the intellectual property rights, or through the various rights that are given to an individual or to an institutions by in the form of intellectual property, as patent law, as copyright law, or as trademark. So now things have revolutionized very much, and it has diversified, it has given wealth to the valued the individual skill, the skill that is not only for individuals benefit, but by and large it benefits the society, and in nutshell to the human beings. So the entire concepts of the economics that were related to trade has now changed. The tension inherent in this dual view of the trade have never been overcome, but still, as stated to you earlier, that what will be the benefit outcome of this trade between the nations, or what will be the outcome of cross border trade, that kind of debate till date has been existing, and You can see here in the picture or the uh, cartoon here that I am showing, that there are various representatives of the countries, and they are all trying to show their products. One showing that their product is better than the other product from the other one, and they both, all these representatives, they are then trying to get the best price for their product. So this always goes, but the hidden aspect nowadays is whether we can achieve the technological advancement through the progress of international trade or not. Here you can see another picture that shows about the mercantilism, that the life of the early mercantile people, that was very showy, because the wealth, they were not very much innovative how to use the wealth like nowadays. The resources or the potential of the money and the wealth is used for innovating something new or to creating new technology. That was not the practice in the medieval time. So mainly it was to buy the goods of luxury or to invest in their personal benefits or in personal show off, what we term today as the conspicuous consumption. Next is the first reasonably systematic body of thought devoted to international trade is called mercantilism and emerged in the 17th and 18th century Europe. So later on, these ideas that got finally embedded in the concept of later mercantilism. This was after the Industrial Revolution that started in the medieval Europe. Now, with the Industrial Revolution, there was a great scientific progress, and after this scientific progress, the nations, they wanted to sell their technological skills to the other countries. So they connected it with the concept of mercantilism. If we go back to the history of company law, we will find that in England, the company law emerged with the idea that two or more person, those who are interested in manufacturing a good, they can establish any such unit or any such company that will be accepted by the charter, that was known as the charter companies, or that can be that can be accepted under the companies laws of England. That was the second method, or by the statute, or that means by a special law created companies. So they categorize the companies, the formation of the companies, and this led to the gradual liberty being given to individuals or the group of individuals for selling their technological products or selling their technological ideas to far off places by their representatives. Like the East India Company came through the Charter Act of the England, but basically they came with the idea to start trade with India, although later on they played the tricks and influenced the Indian political system. That is different story. But if we try to find the traces how the East India Company originated and what was the reason it reached India, so there we can see that the genesis of it lies with the industrial progress and advancement in England, and that led to its promotion in the far off places. This was based on the balance of trade and on bilateral treaties. Now, the core thing that earlier existed between the loss and profit had also changed after the Industrial Revolution. That was based on calculation of the balance of trade. That means to what extent one country A is exporting to country B. For example, country A and this is country B. Now country A exports its good to country B. Let's say it exports cars, and country B exports its wine. Now, as per the principle of balance of trade, we need to know which country is benefited out of the trade between these two articles or these two goods. So definitely, as you know, that cars are an expensive material or expensive goods. Definitely country A will have positive balance of trade. Country A will have plus. I put it here, the plus, that is its balance of trade will be favorable. That means it is gaining out of this trade relationship with country B. Second is, the trade was now in the medieval times after this industrial revolution mainly based on bilateral treaties. Bilateral treaties here mean that country A will give preference to the goods from country B, or country B will give preference to the goods of country C, and likewise the country C will give preference to the goods of country B. But they will not give the equal preference to the goods from country D, because they are having bilateral treaties. That means one country will take into consideration the interest of the other country, and the same very country will take into consideration the interest of the country that has promised to do so. So that was like going on, the new kind of relationship was created. Now this was also in order that one country should not get weakened out of trading with many countries. Like if country A is trading with country B, country C, country D, it could be at times country C, country D, country E, they all unite and then they wage a war against country A. So that can be thinking that it is a very prosperous country. But in order to avoid these kind of practices, or in order to avoid these kind of risks, the trade relation remained confined, that if country A is getting favor from country B, then country B will give favor to country A likewise. Now, but if we compare this with the present time, that is after the formation of the WTO, there is no such popular practice of bilateral treaties still in existence, and neither this has been very much liked by the WTO, or we can say it in the legal terms that it has no legality in terms of the trade through the WTO as an international trade institution. So it has no legality. Bilateral trade has no legality, except if it is based on the regional trade alliances, or if it is created under certain exceptions. A favorable balance of trade is one in which the value of domestic goods exported exceeds the value of foreign goods imported. That means, what do we mean by the term favorable balance of trade? That means if country A is exporting its goods to country B and also getting its goods from country B, that means country B is exporting its goods to country A. Now, out of this trade relationship, if country A has to pay less, that means it is gaining out of this trade relationship, then we call it as a favorable balance of trade. For example, this is country A. Country A exports goods worth $10 million. It imports goods worth $8 million. So this means out of this trade relationship, it is in a winning situation by $2 million. So we can say that it has a favorable balance of trade of $2 million. Then comes the modern days concept after the formation of the WTO. So after the formation of the WTO, we say nowadays it is based on international economic law. The term used is international economic law. So law is also alongside the economic. It is not purely economic concept, that is how the WTO is working, but there are legal concepts also alongside or complementing the economic concept. Now, firstly, I would like to share that why the concept from two different disciplines have been taken together in this institution. Economic concepts, as you know, they are basically the trade related concepts. And these trade related concepts are not mainly with regard to the local market, but cross border trade, that is states, state A trading with state B, and how the market of state A is can accept the goods of state B, that kind of concept. Now law helps here because law is based on some core principles of equity, then justice, then it tries to reduce the possibilities of exploitation of the nations by means of trade. Also, law through the principle of equity believes or sets the objectives that how the goods can be shared among all the people in a best possible manner. That means there should be no monopoly or some group of people who have done good in the trade practices or have monopolized the trade practices. They should not start ruling the economy, or they should not try to dictate their terms. For all this, there has to be some legal instruments, or there has to be certain legal measures that can create faith among the people, or among the people in general, in all these trade objectives. So nowadays the trade is not simply whether I will be benefited out of this deal or not, or whether my country will be benefited every time we make the trade deal. That is no more the idea, but the idea is that through this trade, how we can do the best to all the people, or at least the people in general. And secondly, how we can make the production in most efficient manner, keeping in mind the interest of the consumers, as the law takes into consideration the interest of the consumers. Then how the goods can be reached, or how the goods can be delivered to the consumers at the most cheapest price and in the best quality. So all these new determinants have been introduced in the concepts of international economic law, which is the core aspect of the WTO. This is a modern concept. That means the earlier, if you want to know what the concept was existing prior to this international economic law, that was we can say purely capitalist system, or the capitalist system very much in its height led to the colonialization of the countries, where only the benefit of the colonialist was seen, or the benefit of those countries who have achieved industrial advancement was the primary motive. But what was the consequence? That has led to the First World War, and that has also led to the Second World War. And not only that these countries were involved in these catastrophic war, but that led to the wastage of human resources, entire or you can say great amount of human loss of life and resources, and no one was the winner in true sense. So basically we need to rationalize that why the nations go for the war, or why that idea was coming into their mind to get things out of the war, or what to get out of the war. So realizing the fact that mainly it is the economic advancement or economic achievement or economic benefit that leads to the consequences of war. So why not to decide those economic goals and share those economic prosperity among all the nations. That was the idea for which the new concept of international economic law was generated. It encompasses a complex architecture of rules governing international economic relations and transboundary economic conduct by states, international organizations, and private actors. So what is covered under the economic law or international economic law? A complex architecture of rules governing international economic relations. That means firstly we try to rely upon economic relation among the nation. Earlier it was the political relations that were mainly the core aspect, but now it is also the economic thing, the relation between the countries based on the economic benefits. As we see today, the goods, the final goods that is in our hand, for example car or television set, Their parts are manufactured in many countries, maybe in China, partly in Hong Kong or in Germany. So there can be many countries involved in the manufacture of the television or the car. So that is how the new form of economic relations are created. And how that is created, because it could be some factors in the production are available in country A, they are better. Some factors of production of the same goods that is involved in the manufacture, they are available in country B, and the third one in country C. So for example, let's see country A, country B, country C. Now country A has cheap labor, country B has good skilled engineers, country C has, let's say, uh, it is good in doing the finishing work, or assembling. So we take the example of car. So if we want a car that should be sold in the market of either of these countries A, B and C, then and that should be available at the cheapest price and in the best possible manner. So we take the resources, that is the factors of production or the determinants from country A, the cheap labor from that place, then the skilled engineer from B, and then the C, that is the assembly work can be done here. And the cost of the final will be the good quality car at a cheaper price. But let's say if we only allow country A to manufacture the car, then what will be the outcome? Country A can only provide cheap labor, but neither it has skilled engineers nor it has good assembly line. Therefore, we cannot get a good quality car from country A. Now take the example of country B. Of course, it has good skilled engineers, but it does not have the cheap labor. So the car that is solely produced by country B, that will be expensive, although it may be of good quality, but it will be of higher price. Now the same car, if it is manufactured solely by country C, then we may not be having the good skilled engineers, neither we have the cheap laborers. So again, the same crisis arises that we won't be getting the car at a cheaper price or not of equally good quality. So this is the new form of economic relations that are created. They are quite distinct than the earlier relations that were based on the political concepts or based on the political ideologies or the religious ideologies. Economic relation and transboundary economic conduct by states, international organization and private actors. But then the countries do have to abide by the transboundary economic conduct. That means the rules that are regulating the behavior of these business sector, that has to be, they must abide by it, those rules. I mean to say, if there is a regulation to accept the patent law or the regulations to accept the copyright law, then that must be, those obligations must be fulfilled. No one would be willing to give its technology for free. So whatever hard work has been done or whatever value has been invested for that, the price has to be paid fairly. That is what it means, the fair price in this regard. International organizations and private actors. Now the role of international organization is very relevant, because we cannot expect such like ideas to be created based on the bilateral treaties, because when we talk about the international trade law, that means it requires a legal platform that is accepted on a global basis. So that platform is created by international law. That is through the treaty obligations, and through the treaty obligations we can create different set of rights, different set of obligations for the trading partners, for the countries that are involved in trade. So therefore we consider the responsibility of the international organizations to set those ideas, to tell those ideas to the states, those who are the member states of those organizations. And finally, it should be simplified in such a manner and should be taught, and also they should be reached to the academic line in such a simplified manner that even a common person, whoever is in one way or the other educated about these international organizations or the role of international organizations, realizes that what kind of obligations are created. So it is a great work to be achieved through these organizations, that those values that are generated, or those relationship between the nations through the economic advantages that is created, that must be not only confined to the leaders of the state, but it should reach to the bottom line up till the common man also. So then it will be that how far these concepts of international economic law are effective. Next is the private actors. Private actors are the stakeholders, the producers, like basically it is not the government which is manufacturing the goods. Basically it is the industrialist or those who are involved, the private actors, those who are involved in manufacturing, they must accept those obligations or those values that are enshrined in these international organizations. Sometimes they may do this intentional mistake, and sometimes that can be incidental mistake. So we need to cautiously rationalize whether the disobedience or let's say defiance of these obligations, that is simply an intentional defiance, or it is probably something that has been overlooked without such intention, or there has been an accidental mistake. So these create a very complex architecture, or let's say the complex structure of the rules within the international institutions while regulating the international trade in the modern times. Now, why this was, I again repeat here, why this was necessary, and why this objective has been settled, that these ideas and values must reach to the common man, because this was an outcome after realizing the mistakes of the two world wars, and also realizing the mistake of the colonialist mentality. Colonialist mentality was not purely a political mentality, but it was a political and economic concept. How far those colonial countries can enrich themselves by exploiting those colonial countries, the countries to whom they have colonized. Now that has to be eradicated by a better economic ideas. That was the thing, replaced by the better economic ideas. So therefore a new role was enshrined to or given to these international institutions in this regard. It covers the regulation of cross-border transaction in goods, services and capital, monetary relations, and international protection of intellectual property. So the new roles that were given to, or sorry, that are given to this international institution, they are regulation of the cross-border transaction as stated to you earlier in regard to the goods. Now here it is not only regulation of the trade with regard to the natural resources, like earlier the iron ore was taken by the Britishers, but now it is mainly regarding the finished products, the final goods that are being manufactured, how they can be sold in one country to another country, how the fair price can be quoted of that product, and if the fair price is not quoted, or if any predatory practice is performed by or practiced by any country, then what can be the remedies to the affected country. Services. The new addition is services. Services here means the human resources, they have been valued, because there can be the human beings with great skills, like there can be good engineers, good doctors, good software professionals. Now they are good service provider to the countries or to the economies, and they can be, their potentials, their skill can be used by many different countries. So their cross-border movement and whether they get the fair value of their services, that is also regulated by the international institutions nowadays. And capital monetary relations. Now, what are the capital monetary relations? Nowadays, as you know, the WTO is linked with International Monetary Fund. Since the changes has to be brought in accordance with the new role played by the WTO and other international institutions, so that require sometime monetary support. For example, if India is allowing import from all the countries, or any developing country or less developing country has opened its market for the import from all the countries, then it could be they may run into deficit balance of payment, or they may run into deficit foreign exchange. Then how their economy will be sustained, or from where will they get the support, the capital support? So all that is supported through the international monetary organizations, or IMF, International Monetary Fund. They do two kind of support. Firstly, they give the loans, or secondly, if a country is not willing to take the loans from them, they also give the advisory function. They can advise that in what method they should adopt in order to cope up with these international trade challenges, or what method they should adopt when they are inviting the imports, or they are allowing the imports from the various countries. And the international protection of intellectual property, as stated to you, that we now consciously give value to the skills of the human beings, because the international law is very much supporting the value of intellectual property. Why it is supporting the value of intellectual property? Because earlier the concept was the wealth of nation is based on its resources like gold, silver, petroleum. But now the concept of wealth of nation is how better they can perform, or what kind of technological lead they can give. That means whether they are frontiers of technology or not. For example, Japan is one country known for its best electronic products. Germany is known for its car manufacturing. So these are, or United States is another country that invests a lot of money, and they have very good infrastructure setup in research and development. That means they are helping the humankind in advancing the technological setup, in advancing or in progressing the limits of the technology. So now those people, or whether they are from any country, now it's not only confined to those developed countries, but from any country, those group of people who are advancing the frontiers of technology, they are considered now benefiting the humankind and creating the wealth of the nation. So they must be given their due, and that is through giving due regard to the intellectual property. That means anyone who is using their ideas, their innovation, must pay the due value to those people. Trade between business unit is regulated by executive as part of their collective responsibility, whereas between the nation it is large-scale economic activity. This explains why there are institutions established by treaty agreements to regulate trade according to the agreed rules. So we usually understand that the business deals is between two parties, private parties, and they will their trade relation will be governed by the terms of the contract. That aspect still exists. For example, I would say that if someone from India, anyone who is involved in business in India, privately can enter into a contract with someone from abroad, and their trade relationship will be governed by the terms of the contract. Accordingly, they have signed. Now, what the treaty plays the role, or where the treaty plays the role, is mainly with regard to the trade between the nations. For example, if India is importing petrol from Qatar or Kuwait, then on what terms and conditions India is importing petrol? So all the private people, private parties from those countries, they are selling fossil fuel to India, or the petroleum to India, they will be considered not separately, but it will be considered that we are getting crude oil from this country, and if there is any dispute with regard to the quality of the crude oil, with regard to the price of the crude oil, then that will be settled between India and that very respective country, not between the party. So the terms of the trade here through international institutions are signed between two different states. That is where the international treaties plays the role. That is where the international institutions plays the role, not where the private parties are signing their separate treaties. So that comes under the international contract law, and in international economic law we mainly talk about the trade between two different states and the terms and conditions based on which it has been signed between the two different states. This explains why there are institutions established by treaty agreements to regulate trade according to the agreed rules. Presently, it is the WTO that acts as an international trade regulatory institution. For the promotion of free trade, the WTO is based on the premise for the creation of a market environment through an approach of cooperation among the nations. Now, presently, it is the WTO that regulates the trade between the nations. Earlier, it was the GATT, but GATT was not an institution. It was basically a contractual document between the parties. Now, here, in order to establish such a potential that it can cover all the nations of the world and then regulate the trade throughout all the nations, it has started with a new principle, that is the principle of free trade. That means there should be the trade without any restriction. There should be no protectionist measure among the member states. So it has started with a very idealistic idea that there should be free trade. For the promotion of free trade, the WTO is based on the premise for the creation of a market environment through an approach of cooperation. Now, second step is that how this free trade can be reached, or that how this idea of free trade can be achieved. Now, that requires market environment to be created among all the member states of such nature that there is no protectionism, there is no restriction on the goods from the foreign product. Now, that is further devised by using the two concepts, that is most favored nation clause and secondly the national treatment clause. Now, what is most favored nation clause? Most favored nation clause is if the goods from country A is given preference, then the like good from all the member states of the WTO should be given equal preference. I explain it. This is WTO, and country A is member, country B is member, country C is member, and there are other members as well. So, if country A is allowing good from country C and giving preference, then it has to give equal preference to the goods, like goods, from all the countries or all the member state. So that is what it means by most favored nation. That means when one good from one country is given any favor, then all the nations, all the member states producing the like goods should be given equal favor. Now, why this? Why the term most favored nation has been used here? That is, since prior to the formation of the WTO, the trade relationship between the nations was based on bilateral treaties, or prior to the formation of GATT, the trade relation between the nations was based on bilateral treaties, and those bilateral treaties were not discarded after the formation of the GATT or the WTO. It was stated that there will be a gradual transformation in this bilateral trade relation into a multilateral system. So, accepting the bilateral relationship that was existing and transforming into a multilateral system, they coined the term most favored nation. So, if favoritism have been given to a product from country A by country B based on bilateral treaty agreement, then once it has joined the GATT or the WTO, that means it has joined any multilateral system, then gradually it will give favor to the like goods from all the member states. The second such concept, that was national treatment principle. Now, this was once the goods have entered into, or once the foreign goods have entered into a country, then they should not be discriminated. They should be given like treatment as if the goods are given the treatment that are produced in the home country. That means the foreign goods, they should be given the equal treatment or similar treatment as if the goods that is manufactured in the home country is given the treatment. So, then only we can say the free trade concepts, they have worked in order to fulfill the objectives of the WTO. Next is the classification of the countries, developed, developing and less developed, in the system of GATT and WTO. Now, one very wonderful thing, or let us say one very surprising thing that this institution is working with, is classification of countries, or let us say accepting the countries, allowing them to accept the free trade concept, but then also categorizing them as developed, developing and less developed countries. Now, this classification is not in order to create, let us say, some kind of hierarchy, but basically it is firstly to know the reason for the distinction. Now, the developed countries, earlier they were considered developed based on the GDP, that is, to what extent they have the gross domestic product, or to what extent they have their national income. Now, if we go by that concept, then the national income, or let us say the gross domestic product of the Arab countries, or the countries who export this fossil fuel, that is highest, but we cannot consider them as the developed countries. They are categorized as the developing countries. So, here the classification is based on human resources, the institutional setup, the infrastructure setup, the quality of education, healthcare system and various other aspects that leads a nation to its advancing position, or that leads a nation to a very technological position, a very superior technological position. So, that is how the developed countries are recognized. Then is the developing countries. Developing countries are, there is a very wide range of the developing countries. Some are the countries who are in between, like in between, whose economies are shifting from the rural setup to the industrial setup. They are termed as the developing. Some are who are very close to reaching the status of the developed countries, like China, Korea. Korea earlier was termed as the developing countries, but presently it is termed as the developed country, and several other countries who are termed as developing countries, mainly because it could be they are lacking in their infrastructure setup, but they have good gross domestic product, or some countries they have good infrastructure setup, but they are lacking in their educational setup, or they do not make much contribution in technological advancement. So, there are various parameters applied to different countries to determine whether they are developing countries or the developed countries. The third is the less developed countries, where that is based on primarily on the GDP, which is less than $1,000, the UN GDP, and also they are in a very marginal position. Their economic setup still is struggling, and mainly they are relying upon the export of natural resources. They are very much confined to their rural setup. They are still trying to come up with the new form of economic ideas and the new form of economic setup. So they are classified as the less developed countries. Characterizing their status from the WTO perspective, the nations ahead in the use of technology and able to sell technology in the market are termed as developed countries. Nations depending upon the rural economy are termed as less developed countries, while those in between are termed as the developing countries. Thanks for giving patience and listening to the first part of this lecture series.